there are two of you who don't know me. My name is Alicia. I'm a staff attorney at Disability Rights Pennsylvania. I got hired pursuant to a special grant to represent alleged incapacitated people in Montgomery County and to educate people about alternatives to guardianship. Before I worked for DRP, I was a sole practitioner in Orphans Court. I worked in Orphans Court specifically for about 9 years, mostly in Philadelphia, some in Delaware County, very little bit in Montgomery County. I represented alleged incapacitated people. I represented petitioners for guardianship, and I'm a guardian. I'm actually a court-appointed guardian for about a dozen, or have been for a dozen people. Most of them have died since. So I kind of have seen the whole spectrum of what goes on in court with incapacity proceedings. And I designed this presentation for NAMI specifically. I will say, like, I'm particularly sensitive to people who have a loved one with mental illness. When I was growing up, my mother was institutionalized for most of my life. She was 302'd more times than I could even probably count. I don't know, 20 times, 30 times, 40 times. So I am aware of the plight of the loved one of the person with the mental illness and how much they want to help that person. And I come to it from that angle too, but I'm also particularly sensitive to the person with the mental illness and their rights, because they have the right to make their own decisions. And that's what this first slide is about. People with mental illness, even people who are incapacitated, have the right to make their own decisions, and that's important. And that freedom to make their own decisions, as weird as those decisions may seem or irrational to other people, that's part of their rights to their freedom, to their autonomy, and to their own self-determination. Sometimes, though, people with certain disabilities, including mental illness, might be limited, and they might need help making their decisions. And they might need someone to support them making their decision, or they may need someone to make decisions for them, which would be called a substitute decision maker. And we'll talk about both further on. I'm trying to see if I can make, hold on. I had to get rid of my face because it was like blocking my slides. Okay, you know, someone that I showed this to before I presented it pointed out that most people might not think of mental illness as a disability, but it is. Mental illnesses are considered disabilities under state and federal law. It might vary depending on the issue, but if someone's mental illness requires that they get assistance from someone else or that they get an accommodation, legally they can probably be considered disabled. So this is a disability issue. I'm gonna give like a brief overview of capacity and guardianship. So in Pennsylvania law, according to the code, if it's practiced correctly, which luckily it is in Montgomery County, someone should only get a guardian if they've been declared incapacitated or they lack capacity, and there's no less restrictive alternative to a guardian. So both parts are important before designating someone with a guardian. And sometimes people with mental illnesses are appointed guardians. So what does capacity mean? We talk about someone who's incapacitated. They may or may not get a guardian if there's no less restrictive alternative. What does that mean? Well, in layman's terms, someone has capacity. It means they can understand a situation, the options, the risks and benefits, and use the information that they're given in a logical and rational way to make a decision, and then communicate that decision. It doesn't have to be a verbal form of communication, but they have to be able to communicate what they decide. So with that definition, we can see how someone who has a mental illness might seem incapacitated at times, right? There might be times they're totally illogical, they don't understand the risks and benefits, and they're just irrational. But does that mean they should get a guardian? Well, not according to me, but let's go on. So that's, if someone doesn't have these qualities that I listed on the slide, they could be labeled incapacitated by the Orphans Court. And if there is no less restrictive alternative, they might also be appointed a guardian. But they don't have to be appointed a guardian just because they're incapacitated. Persons with disabilities, including persons with mental illness, they might be incapacitated in some things, but not all things. And they might be incapacitated sometimes, but not always. And we know we see that sometimes with people. People might have delusions about certain topics, things they believe to be true but aren't true, or they might only be delusional or irrational certain times, like when they're having an episode. They could be having a, any number of mental illnesses can give you episodes where you're less rational than other times. So this slide is just a reminder that people with mental illness might have good times and bad times, right? There could be times when they're completely rational, and there could be times when they have an episode. This could be because they stop taking their medicine, or it could be because they're under extreme stress. Any one of those things could cause like some kind of episode where they have delusions or something else, even though they're normal the rest of the, I don't like the word normal, I'm sorry, even though they're not having those kinds of periods the rest of the time. So, but in my opinion, this is my opinion, this isn't like a legal fact, the fact that mental illness is so mercurial and can change, and people can be good sometimes and bad sometimes, and sometimes they understand and sometimes they don't, to me that means it's a particularly bad, that person is a particularly bad candidate to have a guardian. So, and we'll talk more about the alternatives later in the presentation, but, if they're not well now, but they're going to be well 2 months from now, is a guardianship really the best option? Like, I don't think so. Now, there are emergency guardianships, which can be good options if someone is undergoing a particularly immediate event because of their mental illness and they need someone to step in right now to help them. But that, in my opinion, that's a better solution for someone with a mercurial mental illness that changes and ebbs and flows than someone getting a permanent plenary guardian. And the Honorable Judge Murphy might disagree with me, but that's my opinion. So what are some? This whole presentation is meant to dissuade you from filing for guardianship, if you haven't noticed that already. So I'm not going to talk about the process of filing for guardianship. There's other lawyers that can talk to you about that. But the one that you should note is it's very expensive. You need to get a lawyer. It usually costs thousands of dollars. After a guardian is appointed, they have to file annual reports with the court. There's filing fees. Now, you can file a petition to waive those filing fees. Some jurisdictions make it very easy, like Montgomery County, there's a form you can kind of fill out. But some jurisdictions like Philadelphia, you can't do that. You have to hire a lawyer to petition to cancel the fees. So it's like guardianship, the bottom line is expensive, can cost a lot of money, it's time consuming, and if you can avoid it and you don't need it, like, why go through all that? So I don't know if this is a negative, but I have it on this slide. Some people don't understand that if they're a guardian, they can't force the incapacitated person to do everything. So some people go into a guardianship petition thinking, I'm going to force this person to take their medicine or, just whatever. And even if you're guardian, you're supposed to take the wishes and the preferences of the incapacitated person into account. It actually says that in the code. So, you're supposed to work with the person anyway. So there might be a better way to do it other than trying to force yourself on them as your guardian. And finally, it's, the law says, as I mentioned before, that guardianship should be avoided if there are less restrictive alternatives. And the reason it says that is because guardianship is the most restrictive thing. It basically removes the person's rights. Yes, they can't be forced to do things, but people with a guardian are kind of taken out of the equation of their own life. A guardian can make a lot of decisions behind the person's back, like without involving them. I know the power a guardian has because, like I said, I am a guardian. Doctors call me, they don't call the person. Like all the care providers call me. They leave the person who's incapacitated out of the equation of their own life and they come to me first. So that's really taking someone's rights away. And if we can avoid taking someone's rights away and we can keep them being at the center of their own life, that's important, I think. So this slide is a reminder of what guardians cannot do. So a guardian can make even though a guardian by law is supposed to consider the preferences of the incapacitated person, They don't have to, right? They can make a lot of decisions for the incapacitated person, except for illegal decisions, and these are illegal decisions. So there's certain things a guardian cannot ever do, right? And important to note here, because this is a presentation for NAMI, is that a guardian can't admit their ward to a psychiatric facility. So when I was in private practice, I did have people come to me saying that they wanted to become guardian of their loved one who was mentally ill so they could, you know, help them. And when I asked them a lot of probing questions, it turned out they wanted to commit them to a psychiatric facility. And I had to tell them, you can't do that. Like, it doesn't. So if you're aiming to become a guardian to commit your loved one, that's a really bad reason to become guardian, because you can't do it anyway. It's against the law. And there's there's federal laws that kind of prohibit forcing people to take their medication. I mean, there's some exceptions, but in general, like if you're a guardian, you can't force medicine down anyone's throat if they refuse to take it. Now, if they don't refuse, you can certainly give them medicine, choose which medicine they take as their guardian. But if someone outright refuses medicine, you can't open up their jaw and put it in there. And that's another thing people don't understand, that I've encountered when it comes to their loved ones who have a mental illness. They think, well, if I can only be the guardian, I could get them to take their medicine. Like, no, you really can't. So if that's your reason for wanting to become a guardian, that's a pretty bad reason. You know, you can get electroshock therapy for someone. That's a mental illness thing that most of us know about, but you have to go to court to do it. You can't just choose it on your own. So there's other things you can't do if you're a guardian. They're listed on the slide. But again, if you're hoping to get your loved one into a facility as a guardian, can't do that. So maybe we should look for a better option. This slide just kind of emphasizes more bad things about guardianship, I guess you could say. It's very stigmatizing for someone to have a guardian. And, you know, once you get that label of being incapacitated, it's hard to be listened to, because people in your world are going to want to go to your guardian and not to you about things that are in your own life. So again, I mentioned this, that someone who is a guardian cannot commit the incapacitated person to a psychiatric facility. So how do they get into a psychiatric facility? Well, they have to become 302'd, or they have to sign themselves in. So I've had, as a guardian, it depends on the hospital. Like some hospitals are even wary about letting people who are declared incapacitated sign themselves in, you know, because they question, can this person sign themselves in if they're incapacitated? So getting someone into mental health treatment can actually be more difficult. If you are a guardian, you kind of just have to let them get 302'd. And I know there's only like 2 people on the right here right now, but like, does everyone know what I mean when I say 302'd? I feel like NAMI would know.
Alicia, yes. We have 16 people on total with us.
Oh, you do have 16 people on. Okay, I'm sorry. I only see 4. So that's great.
That's okay. I'm pretty sure most of our members, if they are members, or if they have been, you know, working with the system long enough, most of our members know what the 302 process is.
Okay. So the 302 process, I'm going to talk about it more later in the outline, you know, in the outline. But basically, it's becoming involuntarily committed. And it's a very traumatic procedure for everyone involved, for the loved ones who call the ambulance or call the police, for the person being involuntarily committed. But the fact is, if someone is incapacitated, like that's the only way they can get into the psychiatric hospital anyway, right? So in other words, if you're thinking, I want to become the guardian because my loved one is resisting going to the psychiatric hospital, well, the process you're going to have to go through is the same whether or not you're the guardian. You're still going to have to involuntarily commit them. And again, some hospitals do allow people to voluntarily sign themselves in for treatment. Some, I've had questions of like, how can they voluntarily sign themselves in if they're labeled incapacitated? But again, if they're voluntarily signing themselves in, you also don't really need to be their guardian because they know that they need help and they're going for help. So it's like a very weird conundrum, right? And again, about the treatment, they can refuse treatment, right? There's exceptions in the Mental Health Procedures Act about when people can get treatment forced on them. Like there has to be like a hearing by a mental health judge after someone gets committed. And then, that hearing can say, if they act out, you can shoot them with Haldol or whatever. But for the most part, you can't force anyone to take their meds, even if you're their guardian. So how does it help? It doesn't, right? So this is something that this slide just touches on something personal that I used to see, especially when I used to work in the court system, like in Philadelphia. And even now we have an intake line at DRP where people call. So a guardianship proceeding, it is in court. Some people can perceive that as contentious. And if you're dealing with someone with a mental illness where they already have delusions and they already feel people are trying to harm them, a guardianship hearing might just exacerbate them. And we have people that call our intake line who have guardians due to mental illness, that's their disability. And they are basically paranoid of everyone and everything. So it might not help things if you petition for guardianship for your loved one. Now, someone else could, that's different, and I'll get to that later, but you doing it, I don't know. So these are the alternatives to guardianship that we're gonna talk about. I brushed on the Mental Health Procedures Act a little already. The Older Adult Protective Services Act, protects people, the Adult Protective Services Act. We're gonna talk about Mental Health Advanced Directives. And again, I know NAMI has a very well-educated, you guys really know stuff, so you might already know about mental health directives, advanced directives, and if you do, I apologize, but I'm gonna go over them because they're probably the most important and most effective substitute for guardianship for someone who has a mental illness. And then I'll talk about some other substitutes for guardianship regarding people's money if you feel your loved one with a mental illness can't manage their own money. So I'm gonna very briefly go over the Mental Health Procedures Act. There's many sections to it. Some people can voluntarily commit themselves. That's under Article 2. People can sign themselves in if they need mental health treatment. But we all know this one, Section 302. And, so Section 302, we all know as 302ing someone. It's calling the police or calling the ambulance because someone is in immediate harm to themselves or others. You're afraid they're gonna hurt themselves, cut themselves. There's also things in the act about if they're really in danger of not nourishing themselves, you feel they're not feeding themselves, all those things. You can call the ambulance, call 911. There can be a hearing, an examination by a doctor, a hearing, a commitment hearing, and someone can stay for up to 120 hours. That's called getting 302. It means they're involuntarily committed. And most of us here are familiar with that very upsetting procedure. So the important thing to take away from this is that that's how you get someone who needs treatment, not by being a guardian. Because even if you're a guardian, you can't force anyone to go into a psychiatric hospital. So 302ing someone, that's the thing to do if they really need it. If someone is not in immediate harm's way, right, but you suspect that they're neglecting themselves or something's just not right about their situation, it might not be appropriate to call 911, but you might want to call protective services. So Adult Protective Services is for anyone over 18 who has a disability. And remember, mental illness is a disability. So let's say you have, you're worried about your mom and she's, you think she's, not eating, or you think she's whatever, living in squalor because of her mental illness. Adult Protective Services is the appropriate agency to call, right? Because she's not in immediate harm. You don't think she's going to hurt herself right now, like you would, that's what you call 911 for, but you just think something's not right. And anyone can call Adult Protective Services, and this is the number highlighted there. So Adult Protective Services can process a call for a lot of reasons that you see on the screen, but the big one for people with a mental illness would be neglect, and that includes self-neglect, right? So someone's not taking care of themselves, you know, they're not eating, or they're hoarding, or there can be so many different things. I can't even think of it. They're doing something, making some strange sculpture out of feces in their backyard. You know, these are all real things that people with mental illnesses can subject upon themselves, and that's a good reason to call Adult Protective Services. They go through a process for the investigation. They will talk to the alleged victim. They will talk to others. They'll review documents, and they'll determine whether or not the person actually needs protective services or not. If the person doesn't cooperate, which we know is very likely with this person with mental illness, their Adult Protective Services can seek a court order to compel them to cooperate, right, so that they can do their investigation. When it's all said and done, the agency can develop a service plan. So that service plan could be anything, right? It could be recommending a day program. It could be moving the person into a nursing home. It could be this, it could be that. But whatever their plan is, if the person cooperates, great. If the person doesn't cooperate, sometimes APS is the one who petitions for guardianship, right? Sometimes they determine this person really needs to do something for their own good, or else they're going to be, you know, suffering the self-neglect, and they can be the ones who petition for guardianship. My suggestion would be, if your loved one is going through these kinds of issues where you would call Adult Protective Services, you might be better off if Adult Protective Services is the petitioner for guardianship and not you. Because, as I said, petitions for guardianship, they're done in court. Your loved one can perceive that as contentious, maybe, and it could create a rift between you and them. So, you know, if they really need a guardian, let APS be the one to decide that, would be my suggestion. So the good thing, I guess you could say, like, APS is, you know, does all these great investigations and tries to help people with plans for their own safety, but they also respect people's autonomy and people's rights and their rights to self-determination. So there is a fine line, I believe, between when someone has a mental illness and they're eccentric or strange, and when they're really doing something to harm. And I feel like APS tries to acknowledge that line and respect people's rights to be themselves and to be weird, right? Because we know not everyone with a mental illness really needs someone invading their personal space. And finally, you know, they can do an intervention by emergency court order if they have to. So this is a little bit different than a 302, but it's similar. So now I'm going to talk about a different alternative to guardianship. It's called supported decision-making. It's just the idea that everyone, me, like you, looks to other people to help us make decisions all the time, every day, right? So sometimes people with disabilities might need more help than others, but they're just still getting help and asking for opinions and just asking people to weigh in and help them. And that's called supported decision-making. There's not a supported decision-making like law in Pennsylvania, but there was a case called In Re Peri, where the Supreme Court of Pennsylvania basically said that if someone has a circle of support and people helping them, they don't need a guardian. So if your loved one allows you to help them in that way, that's a good, just keep doing that. That's great. But we know that doesn't always work, especially with people with a mental illness, right? Because sometimes people with mental illness are combative, or they're defensive, or they're paranoid. So supported decision-making only works while the person is allowing you to help them. If they don't want you to help them, you know, you can't force yourselves on them. So now we get into like the nitty-gritty. This is the best, in my opinion, substitute for guardianship. It's called the Mental Health Advanced Directive for people with a mental illness. And a Mental Health Advanced Directive, you guys probably already know about it, but if there's like one person on here who doesn't, then it's worth it for me to do the presentation. So it allows people to be involved in their own mental health treatment. And it gives them the most autonomy, and it allows them to pick and choose like what they do and they don't want for their mental health treatment. One of the I don't want to say drawbacks, but you know, one thing about mental health advanced directives is they're only good for 2 years. So you kind of have to stay on top of them. But if you can convince your loved one to create a mental health advanced directive with you, that's a great alternative. And we'll go into more detail about what they are. So mental health advanced directives, there's 2 kinds, but basically 3 kinds. So one is a declaration. It's kind of like a living will, but for mental health. It lists things that the person wants and doesn't want for their mental health treatment. Then there's a power of attorney, which is exactly what it sounds like. It's the person choosing who they would want to make mental health decisions for them if they were to become mentally incapacitated. And then there's a combination. And there's links here. This link is the best, www.ma. I'm sorry, I don't know if you see what I see. mhapa.org. They actually have forms online that you can just like fill out, and everything is correct, like legally in terms of the requirements. So, sorry. So how does a mental health advanced directive work? So they have to be made when someone is lucid. So if you have a loved one that has one of those mental illnesses we discussed, where sometimes they're lucid and sometimes they're not, you have to draft it when they're lucid. It's not legally valid if they're drafting it when they're in a mentally incapacitated state. But when they become incapacitated or in a mental health crisis, they can use the mental health advanced directive to govern their care. It could be given to their doctors. It could be given to anyone really who's helped care for them, and it'll reflect their wishes that they had when they were lucid. It's a really good, it's just a really good thing to do, because most people have very strong opinions. Like, again, we get calls on our intake line from the state hospital. People are very upset about the medicine they're given. They're saying, like, I don't like this medicine. They're not listening to me. You know, this medicine doesn't make me feel good. I've never liked it. I like this other medicine. You know, but if you have a mental health advanced directive in advance, you say, like, I don't like whatever, Halidol. I do like lithium. And the doctors can kind of use that as a guide to help you or your loved one with, you know, whoever has the directive with their care. The only, you know, the exception to that would be, like, if what the person is asking for is unreasonable and isn't up to medical standards. Like if they put in their directive they want to be bled by leeches or something like that, that's not going to be followed because nobody does that anymore. So I'm sorry, I was in some. So the declaration, these are just instructions on how to do a declaration. You have to mark your preferences with your initials. Persons should understand that when they're making a declaration, that it's a guide. For example, people can put in a declaration hospitals they do and do not want to go to after they get, like if they become involuntarily committed, after the initial period of time, people can be transferred to different psychiatric hospitals, right? So they could put, I hate Friends Hospital, but I really, really love Belmont Hospital. I want to go to Belmont, right? But if Belmont's full, there's no beds available, they're not going to go to Belmont. But it's still better than not saying anything, right? And at least maybe they won't go where they don't want to go. People should give copies to their loved ones, their doctors, their social workers, just in case they get involuntarily committed, so it's available. And this is how the Mental Health Advanced Directive declaration looks. People talk about when it becomes effective. They can say it becomes like effective when they become committed, or they go for outpatient, inpatient, whatever, whenever they want it to become effective, that's when they write it, right? They have control of their own mental health declaration. They talk about all these treatment preferences, what they do and don't want. You know, electroshock therapy is interesting. All through the code, I guess legislators hate electroshock therapy because you always have to specifically, you have to get permission for it. You have to expressly state you want it. If you don't state you want electroshock therapy, you won't get it. I think it's like out of fashion anymore. Same with drug trials and experimental treatments. So you can revoke your declaration as long as you have capacity. If you don't have capacity and you get involuntarily committed, you can't revoke it until you're deemed to have capacity again. It terminates automatically within 2 years. This is an important one. Again, I always try to avoid guardianships, but if someone does need a guardian, they can put in their mental health advanced directive who they prefer that their guardian is, you know, which is important. If the court ever deems the person does need a guardian, at least their preference will be heard. So this is kind of a sample of what a mental health advanced directive looks like. Again, you could follow the link. We have resources on our webpage for mental health advanced directives. And this is a different kind of mental health advanced directive I'm going to talk to you about now, is a mental health power of attorney. So a mental health power of attorney has to be expressly written separate from a regular healthcare power of attorney. I'm sorry, what? Did someone have a question, or was that just feedback? Okay.
I have a question, but we can wait to the end if you'd like, or if you want to answer it now, it's up to you.
I could answer it if I know the answer. I might not know the answer.
Somebody asked, is a durable power of attorney different than a mental health advanced directive?
Yeah, well, so a mental health advanced directive is a generic term for either a mental health power of attorney or a mental health declaration. They're both designated by a law that was passed in 2004. But yes, if you have a durable power of attorney, unless it follows what was outlined in the law for the Pennsylvania Act 194 in 2004, it doesn't, I'm sorry, I'm talking too much. A regular power of attorney doesn't really count as a mental health power of attorney. They're separate things, and they need to be either executed separately, or if they're executed together, you have to make sure the mental health power of attorney conforms to the laws for mental health power of attorneys. So, and they don't have to be the same person, right? You could have your power of attorney for healthcare can be a different person than your power of attorney for mental health. So it's really, the mental health power of attorney is someone you designate to make decisions for you if you have a mental health crisis specifically. So to elaborate a little more, a regular power of attorney can make mental health decisions that are outside of a crisis if they're small. Like, let's say it's just like medicine or something, like, oh yeah, my mom takes lithium, I'm her power of attorney, hey doctor, when she's in the hospital, give her lithium. But if my mother goes into a mental health crisis and she's 302'd, in order for me to make decisions for her, my regular power of attorney is not going to cut it. I need to be her mental health power of attorney to help her with those decisions when she's in a mental health crisis. Does that answer your question?
Charles, if you want to put it in the chat, or if you want to unmute yourself, you're able to.
All right, I hope that answered the question, but I'll take more questions at the end. So they're separate documents. One doesn't necessarily like replace the other, especially in a crisis situation. If you want a power of attorney to make decisions for you, it has to be a mental health power of attorney. It's not a regular durable power of attorney.
Thank you. That does answer my question.
Okay, thanks. So mental health power of attorneys, by law, they kind of have to look like this in terms of you have to designate the agent, an alternative agent. If you want an alternative agent, when it kicks in, like some people might only want it to kick in if they become involuntarily committed. Some other people might want it to kick in if they start outpatient treatment, you know, whatever. And then the rest of it is really similar to the mental health declaration in that they talk about their preferences. The difference between this and a mental health declaration is you're also choosing someone else to speak for you if you have a mental health crisis. Whereas the declaration, you're not choosing anyone else to speak for you, you're just listing what you would and wouldn't want if you were in a crisis. So most people use a combined form where they're doing one or the other, but not everyone has someone they trust and they don't want to appoint a mental health power of attorney because there's no one that they trust to make decisions for them. So that's mental health advanced directives. I think that's really important. I honestly think everyone who has any kind of diagnosis, even if it's like a mild diagnosis, should have one, because like even if like my diagnosis is just anxiety, I never know when I might have some kind of breakdown, right? So I have one, even though I've never been involuntarily committed, and definitely people who have any kind of mental illness should have one, because they're really being proactive and making the most choices about their care when they can, so that if they ever have a breakdown in the future, like they're covered, you know. This is just a slide to remind people that even if you have a mental health power of attorney or a mental health declaration, you can't really prevent being involuntarily committed if you meet the criteria, right? Look, now I'm saying like you. Sorry about that. I started with your loved one. Now I'm saying you. It doesn't matter, but people still can get committed even with these. If they still meet that criteria where they're a danger to themselves or others, they're going to get committed even with the mental health advanced directive. And if they're resisting treatment and they don't want to go to the psychiatric ward, again, the 302 is really the only way to get them there. So this is kind of comparing, you know, because I had the last time I mentioned this to someone said, well, what's the point if you still get, you know, if I can't force my daughter into the psych ward as her mental health power of attorney against her will, what's the point of having it? Or what's the point of having the mental health advanced directive at all if she still has to get involuntarily committed? And the point is this: someone has a mental health advanced directive. They're going to get better treatment, and they're going to get the treatment that they want, that they chose when they were lucid. Whereas if someone gets involuntarily committed and doesn't have that, the doctors are just like shooting in the dark, right? They don't know. We all know people that have been given the wrong medicine, bad medicine. You know, it just helps so that after you get committed, you go to a place you might prefer. You're given medicine you might prefer. And it will increase the likelihood that you're going to recover, or that your loved one is going to recover. And it will increase the likelihood that you won't be in there as long, right? Because they're not just taking guesses as to how to help you. So it's a really important thing to have. I'm going to talk about something different now. I'm changing topic. So I'm not talking about mental health. I'm talking about regular old healthcare. And did I take a, no, okay, I'm sorry. So someone mentioned healthcare power of attorney, a durable healthcare power of attorney. That's what this slide is about. Healthcare advanced directives. So healthcare advanced directives are about someone's general healthcare. A living will is kind of like a list of what you would want if you were permanently unconscious or dying. And a healthcare power of attorney is designated someone else to take care of your healthcare. But again, this document is separate from a mental health power of attorney. This is more about like healthcare, like you need a surgery and you become unconscious, or I don't know, any number of things where you might need someone else to speak for you about your healthcare. So, you know, a person with a mental illness honestly needs both, right? Because everyone should have some kind of healthcare advanced directive for their physical well-being. And if you have mental illness, you need the mental health care advanced directive too. Anyone can execute an advanced healthcare directive if they're of sound mind. So then this goes back again to people with a mental illness. If they're incapacitated or they're not lucid, they can't sign that. So then what do you do, right? So here's what you do. If, let's say your loved one has a healthcare problem, not a mental healthcare problem, just a physical healthcare problem, and they never designated a healthcare power of attorney, and you need to help them with a surgery or something, or anything, whatever, need to get stitches, and it seems weird that it would overlap. But I guess it's possible it would overlap, that they would be involuntarily committed and maybe they would need a physical healthcare procedure too. So there's a part of the code in Pennsylvania, it's called Title 20, Chapter 54, it's 5461, that designates the people that you see on the screen as healthcare representatives. A healthcare representative can be a spouse, adult child, a parent, adult sibling. And healthcare representatives are people who can make healthcare decisions for their loved one if their loved one's incapacitated. So it could be a temporary incapacity, like someone with a mental illness, or it could be a permanent incapacity, like someone with a stroke. But if someone doesn't have a power of attorney, or they don't have a guardian, if you're their parent or their adult child or their brother or sister, you can help them with those healthcare decisions as their healthcare representative. So like, let's say, I don't know, amputations are the one I would always see a lot, like when I was in private practice. So people might have diabetes and they might also have a mental illness and they're neglecting their diabetes. So now they need their foot amputated or their toe amputated, and they're just not going to consent to it because their mental illness, they don't understand that they need it. So that's not a mental illness issue. That's, you know, a medical issue. You may be able to agree to it as a healthcare representative. Now, I'm double thinking that because amputation is such a serious thing that usually the hospitals require like a court order. So that was probably a bad example. But anyway, the point remains, if you're a healthcare representative, you can make most healthcare decisions that are not mental illness related for your loved one without having any paperwork or anything. You just are the healthcare representative because you're one of these people on this list. Again, there's certain limitations for healthcare representatives. Just like limits on guardians, you know, you can't commit your loved one to a psychiatric hospital if you're a healthcare representative. You can't give them electroshock therapy. But other healthcare decisions you can make for your loved one as a healthcare representative. Before I talk about money, I'm gonna switch and talk about money, but does anyone have any questions about the healthcare stuff and the mental illness alternatives to guardianship that I already talked about? All right, I guess that's a no. So I'm gonna keep going. So I'm gonna talk about finances and alternatives to guardianship of the estate for finances. So, you know, sometimes people with a mental illness, they might get SSDI or SSI because of their mental illness. They're designated disabled and they get that. But they might be horrible with their money, right? If that's the only income they get, you can very easily petition the Social Security Administration to be their representative payee. You'd have to have evidence that they were incapacitated and were not able to handle their own money. Usually what the Social Security Administration accepts is a letter from a doctor. And they would do like an examination of you. Let me see if I have that slide or if I took it out. They would do an examination of you to see if you would be an appropriate representative payee. Yeah, like they would see, like, are you a criminal? Like, have you committed crimes of dishonesty? But if you would be an appropriate representative payee, you can receive their money for them on their behalf. And sometimes that is necessary with certain people with a mental illness. But it's a lot less restrictive and a lot less overwhelming than being a guardian, right? Because being a guardian, there's all kinds of filing requirements. You have to go to court. Being a representative payee, you just have to contact the Social Security Administration, basically prove to them, and it's easy to prove that the person is incapacitated and can't handle their money, and that you would be better to handle their money. And then they will send the checks to you or direct deposit them to you. You have to spend the money for them. You can't spend it for yourself or you will be committing a crime. And you have to save money you don't spend. But, you know, that's a really simple and good alternative and a lot more easy to reverse if the person ever gets well. That's just a better alternative than being a guardian, is being a representative payee. Another alternative, again, this depends on the person's lucidity, is the financial power of attorney. Just like the healthcare power of attorney, this can only be executed when the person is lucid. So when they're having lucid time or scene time. But if it's a person, you know, like let's say they have bipolar disorder, and sometimes they're well and sometimes they're not, you could say to them when they're well, look, I noticed when you're, you know, manic, you really aren't great with your money. Maybe you want to make me your financial power of attorney. How does that sound? And if they agree, when they're lucid, you can execute a financial power of attorney and you could manage their money for them, right? But again, they have to be lucid. They have to agree. And I think this is the last option I have, is a trust. So a trust, if let's say the person who has the mental illness, your loved one, is, let's say, a child, and you want to give them money to care for them, but you don't think they can manage it themselves, or you know, or when you die, you want them to inherit money, but you know they're not going to be able to take care of it because of their mental illness. You could designate that the money go in a trust. And trusts are a legal instrument when you, like the settlor or somebody, puts money or property, could be a home, into a trust for a beneficiary, but someone else manages it, the trustee. So the trustee could be a bank, it could be a lawyer. And so if you're really worried about your loved one, the beneficiary, not managing the money well, you could put it in a trust and have a trustee take care of it. Now, if the person is getting benefits like Medicaid or SSSI, you want to make sure you talk to a lawyer that understands special need trusts, because if a trust isn't set up correctly, the person could lose their benefits. But if a trust is set up correctly, that's a good way to make sure people are taken care of and not have to worry about them blowing the money. And I've known people who have had trusts, people with mental illnesses, and they've had trusts that have just paid their nominal bills, you know, or paid their property tax, just whatever the settler felt they couldn't do on their own, they designated a trust for. So, oh, this is fast. I took out a lot of slides. I guess that's okay. So, you know, my last thing is when I checked the enrollment for this, there weren't too many people who were already guardians who were registered for the course. But if you are a guardian, I want you to consider if terminating the guardianship would work. Like, you know, there could be reasons you have the guardianship that we did not discuss in this presentation. But if, you know, you've come to realize that the guardianship was maybe to help the person with their mental illness, and from this presentation you can see what you can do is relatively the same with or without a guardianship, then you might want to consider terminating it. It can always be terminated not only if the person's regained capacity, that's one reason, like let's say their mental illness is under control now, then you can terminate a guardianship, but just if, you know, if it's burdensome anymore. I know some jurisdictions will consider terminating the guardianship, and you would ask for a review hearing from the same court that appointed the guardianship to begin with. And you would have to prove that a guardianship is no longer needed, and the burden of proof is just more likely than not. So it's not a really hard burden of proof. But I mean, there are sometimes people do need a guardianship for a specific reason, that maybe some reasons we didn't discuss here. But I would also encourage people, if they really feel like they need a guardianship, to ask for a limited guardianship just for what you need. You know, like it could be for, I don't know, securing housing or applying for benefits. A plenary guardianship is for everything. It's very broad. But a limited guardianship is limited just to what the person needs your help with, and then that way they're retaining their rights to make decisions, and even to fail, right? Even their rights to make bad decisions, which is still their right, and their dignity a little bit, which I think people are entitled to. So,
Alicia, we had a question
Sure.
in the chat that said, could the mental health directive work in legal issues, or is it just mental medical issues? Like, can they allow it to serve as us being their mental health advocate in a legal setting?
Like their lawyer? I mean, people would need a lawyer in a legal setting. Well, because here's the thing. So the rules of professional conduct for lawyers, there's a rule. I don't know if Rich is on here. He's my coworker. I think it's 14.1, or it might be 1.14. I always get it mixed up because I'm a little dyslexic. But what is it, Rich?
1.14.
1.14. Okay. So 1.14. So there's already a rule of professional conduct that says if someone is incapacitated, and it doesn't, like, it could be any kind of incapacity, right? It could be an intellectual disability. It could be a mental illness. If their lawyer sees that, their lawyer is allowed to consult with other people to help them. It could be, and they're allowed to consult with their advocates, with their supports coordinator, their social worker, whoever the lawyer feels he has to consult with. And the reason that rule is there, right, is because normally when you have any kind of legal matter, everything is confidential between you and your lawyer can't talk to anyone else. So that rule was added because there was a recognition that if someone is incapacitated, either intellectually or mentally ill, their lawyer might have to talk to other people to serve them well. So so the mental health power of attorney doesn't really allow you to be that person's legal advocate, but the rule of professional conduct 1.14 does, in that you could say to the person's lawyer if they got arrested, you know, this person is incapacitated, they have a mental illness, they don't really know what's going on, I'm here, like, talk to me, you know, and he will be allowed to talk to you under that rule.
Awesome. Thank you. Joanna, if that helps you out, that's wonderful. And if you have questions about contacting the public defender's office, they do have folks who work with those who live with mental illness. So you can always give me a call at the office. And she says, and Joanna, feel free to unmute yourself if you can elaborate better speaking than typing.
Oh, I'm going to try to open the chat. Let me see. Okay, so I feel like all the questions in the chat I've answered, if I did answer them.
Yeah, Joanna says, and what if you're not given that opportunity?
Well, I mean, the thing is like the mental health power of attorney and the regular power of attorney. I mean, so power of attorneys have to follow state law to be valid, and that is not really a clause that I'm aware of for power of attorney. I guess someone could add it and slip it in and like hope, but that's like that's a really bad thing for me to say as a lawyer, right? Because that's like saying this is an illegal power of attorney. I would just start with that option and say, look, I'm aware of this rule of professional conduct 1.14, and it says you're allowed to speak to me because this person is incapacitated. Can you speak to me? I mean, I wouldn't go in presuming that's not going to work. It might work. And if it doesn't work, I don't know. See, the thing about people, like, and we're getting off onto like a different topic that I know less about because I only practiced criminal law for 2 years, but I mean, people have a right to confidentiality. Like, it could be that the person doesn't want their lawyer to talk to you, which is different. Like if she outright says, I don't want you to talk to so-and-so. But if she says nothing and she doesn't have capacity, I would think their lawyer might speak to you.
I'm the one that's been writing those questions, and the only reason why I ask you of this is because my son has unfortunately gotten in trouble with the law 3 times in the past year, and twice in Wayne County, and this last time in April, Lackawanna County. And thank God, and fortunately for Lackawanna County, they have 3 different court systems, I guess, not just the regular circuit court, but they have drug and alcohol court as well as mental health court. And when my son, he always gives me permission to speak to whoever on his behalf, in front of him, of course. And when he's not around either, he always gives permission for everyone to speak to me. Lackawanna County, the prosecutor and the public defender heard me out, and luckily they just, they didn't drop the charges, but they lessened them to the point where he just got a fine as the same as you would get a traffic ticket. Unfortunately, the 2 times he got in trouble last year in Wayne County, they crucified him. They wouldn't hear me out. They didn't want to, they know his history and they know about his mental illness. And all they keep telling me is I need to straighten my kid out before things end tragically for him. Because one of these days, it's going to end very tragic.
Well, that sounds like more a decision on the half of the district attorney. You know what I mean? Like, I don't know. I mean, I would think you'd have to talk to your son's lawyer, but if the district attorney is going to be super strict.
Super
Yeah,
strict.
I mean, that's not, they could just be, they might not, like your involvement might not change that. You know what I mean?
That's what I was going to ask you. It doesn't mean anything, even if you, so it's really a courtesy pretty much, this professional conduct 1.14, it's a courtesy.
No, the rule is that his lawyer can talk to you. Did his lawyer talk to you?
Yes.
Right, but that's what the rule says. The rule doesn't say judges have to be lenient on, you know what I mean? I mean,
Right.
there are certain defenses that the lawyer could have brought out that have to do with mental illness, which I'm not going to,
Right.
like, I'm not a criminal defense lawyer, so
Right.
I can't really judge what he did or
Right.
didn't do. But
Okay.
like, but like it's not. That's what the rule says, that his lawyer can talk to you to help him prepare his case. But the rule doesn't say the DA has to, you know, like the DA decides the charges, and ultimately, you know, everything's up to the sentencing judge.
Right. Okay. But I'm allowed to speak on his behalf as long as he gives me permission.
Yeah.
Okay.
Right. You're allowed to talk to his lawyer as
Uh-huh.
long as he doesn't say like no, because people always have the right to refuse, right? They
Of
can
course.
say that,
Sure. And he's over 18, of course. Yeah.
yeah, but
Okay.
that's what the rule basically is saying, that you can
Thank
speak
you.
to his lawyer.
Thanks.
Sure, you're welcome. So I have this slide up. It has my email on it, and it has our intake number. If you guys have follow-up questions, contact me or the intake number. I haven't figured out how yet, but Lisa Howard is our paralegal, and people have been emailing her questions. I'm not really sure why. I don't know if they see her email because her Zoom, she like owns the Zoom account. But anyway, if you have follow-up, if you have information.
Your
Ask
screen
a
isn't
quick
shared.
question.
Sure.
Okay, so thank you. If my son, say he has a medical declaration or a medical directive, right? And then we're working on a case right now that's on a magisterial level, but it could go to the Common Court of Pleas, right? And if it does, he could be under medication management. Would that medical directive help him if he's saying, hey, like, this is the medicine that works for me?
Yeah.
Or even,
Yeah.
I don't want medicine, I'd rather work with a doctor to try different avenues or something, right?
Yeah, so this is like part of the Mental Health Procedures Act. There's parts that talk about how you can sentence people to medication management and you can sentence people to treatment. But the bottom line is, like I said, like nobody can force, like they can't force your son to take medicine. If he doesn't want to take it, though, he's not in compliance with the court order, right? So it's like tricky. But what the the declaration can do is be a record that says this is medication. Yeah, this is medication that I prefer. You know.
Right. And what kind of leeway do they have if he steps out of the court order and won't take medicine? Can they put
I'm
him
not
in
sure because
jail?
I'm not a criminal. Yeah, I'm not a criminal
Yeah.
defense attorney, so I'm not really like sure. But I know that you can, like, part of people's sentences can be treatment, and I know if you don't do it, you're in violation. But I don't know what the result of that is. I honestly don't, and I don't want to pretend that I know because I don't know.
Okay, thank you.
But I'm trying to see if I can go back and find. But anyway, there's links. There's a link in here to these forms, which are really easy, and you could fill them out yourself, or he could fill them out. And just remember, he just has to be lucid, like when he fills it out. Here it is. Can you see? Can you see
I think
this?
you need to. No, I think you need to share again.
Okay. Hold on. I don't know. I can't make this bigger. All right. Here.
I took pictures of a lot of them, so that I have that link myself for the form.
Okay. Okay, so I'm sharing this website, which is the Mental Health Association of Pennsylvania. Can you guys see it now?
No.
There it goes.
Okay, and if you go, so the website is mhapa.org/programs, and if you scroll down, it has the forms. So like this is a declaration form that we were talking about. And it's easy because they made it so you just have to fill it in, and you put your choice of facility. Like if there's some facilities that you like, some facilities you don't like. Medication, same with medicines you like, medications you don't like. Or you can put, I don't consent to the use of any medications, because what that does, if he doesn't consent to the use of any medications, they'll have to follow the Mental Health Procedures Act to which involves like hearings and stuff, like to get him to take medicines. They can't just force him, right? They can't, like if he's saying, I don't consent to any medicines, then in order for them to give him a medicine against his will, they'll have to go through all the procedures in the act.
Right. And go have a mental health court hearing, I guess.
Right, exactly. They'll have to have a mental health court hearing. And because sometimes people do get, at the mental health court, they'll say this person gets really out of hand and they're violent. When they get violent, we can inject them with Haldol or something, right? But it's like very specific. It can't just be,
right.
They can't just be forcing everyone to take medicine, right? Because if they did, that's called a chemical restraint. That's against the law. Like you can't drug people up just so they sit there in a chair and drool on themselves. Although I'm sure some hospitals would want to do that because it's easier for them. So he could even mark that. And then it's not saying he'll never have to take medicine, but it'll make it a lot more difficult. But, if he knows the medicine works for him, it's good to list. Why not?
Yeah. Well, and more important, if he knows one that doesn't,
Yeah,
I think.
right. Right, and that's usually the case, right? Because a lot of times people have to go through dozen medicine before they find one, you know. That's why I think this part is too small, right? It says like,
Yeah.
but it doesn't have enough lines for all the medicines people don't like. But yeah, you could add it. And then another thing that's suggested, this is in the slides, but I don't remember saying it out loud, is each part should be like initialed. So it's clear that he knew like what he was doing and signed each part. Because if he doesn't initial each part, they could question like, well, did his mom just fill it out for him and did he just sign the end?
Okay.
And that's why like initialing each paragraph on the left side is good.
All right, that's helpful. Thank you.
Sure, you're welcome.
It's an important document, honestly.
Yeah, it's great, and I hope that you know, some of you didn't know about it before I mentioned it, because then I feel like this was a little bit more useful of a presentation. But
It helped me a lot because someone told him about it, you know, and honestly, like I was a little leery, you know. I didn't understand it fully, but I do now, and I see what a real asset it can be to him. So just for this alone, I'm thrilled to be here. I'm going to encourage him to do this when he's stable again, because he's not right now.
yeah, all right, great. Are there any other questions? All right, well, if there's no other questions, I appreciate everybody. My name is Alicia, and like I said, I'm a staff attorney at DRP. We have a helpline that you could call, like if you have questions. I could put that back up. Or you could email me directly. Just don't email Lisa. She was like, why are people emailing me? Anyway, so this slide is the intake line. You could ask for Alicia, and you won't get me, but it'll get connected to me eventually, or you can email me. There's my email at the bottom.
Awesome. Thank you so much, Alicia. This was great. And I think that the folks who attended agree. And what we'll do is once, since this is recording, we'll send it out to the people who registered, so that way they have it to refer back to and they'll have all your information and everything available. So we really appreciate you taking the time out to be with us tonight.
It was my pleasure. I hope I didn't talk too fast. Thank you.
I mean, we had an hour, right? And we got it. Awesome. If anybody has questions or needs us at NAMI, you're always welcome to call Monday through Friday, 9 to 3. I'm Elena. For those who haven't talked to me before, the person who answers the phones when you call. So if you need us, just give us a call and I'll get this out to you probably next week, because you said Molly's on vacation. She has the list, right?
Yeah, she has the list, and she would know how to get the recorded copy off the cloud. I don't even know how to do it.
Awesome. So probably next week sometime we'll get it, and or whenever she returns, and then I'll send it out to everybody. All right.
All right. Well, thank you so much.
Awesome. Thanks. Have a great night, everybody.
Okay, thank you.
Thank you, everyone.
Thank you.
Bye.